This is the last chapter of California's Civil Procedure Handbook, Rules, Selected Statutes and Cases and Comparative Analysis. Chapter 10, the preclusive effects of prior judgments, starting with Subpart A, California's claim preclusion Res Judicata doctrine from the Sawyer v. First City Financial Corp case of 1981, opinion given by Justice Froelich. Plaintiffs' appeal from adverse summary judgment rulings in favor of all defendants, and understanding of the litigation requires an analysis of two separate cases involving essentially the same parties, of which the present appeal relates specifically to the second. For reference purposes, these two cases will be called Sawyer 1 and Sawyer 2. Each case arises from the same general factual background, which states the principal parties to both cases are the plaintiff Sawyer, owners and sellers of land, the defendants First City Financial Corporation, Ltd., First City, and its subsidiaries, purchasers and encumbrancers of the land who sought to develop it, the Toronto Dominion Bank of California, the development lender of First City's subsidiary. The broad brush of facts is that in May of 1974, the Sawyers sold 32 acres of land in La Jolla, California to a subsidiary of First City FC Financial Associates, Ltd. for $1.18 million, consisting of $510,000 in cash and a note secured by deed of trust in the sum of $670,000. Concurrently with the sale, FC Financial Associates committed to borrow $1.8 million in the form of a development loan from Toronto Dominion Bank. This loan was guaranteed by First City and was secured by a first deed of trust on the realty. The Sawyers specifically subordinated their deed of trust to the new encumbrance. The Sawyers, as part of the sales documents, specifically waived any deficiency judgment with respect to their note and deed of trust, which with the result that after the sales and refinancing, escrows closed. Their sole resource for collection of their $670,000 note was foreclosed on the deed of trust, now subordinate to a $1.8 million first deed of trust to the bank. So we definitely sold the farm. Sold ourselves up the river with that deal. Early in 1975, FC Financial Associates discontinued payments on the note to Toronto Dominion Bank, asserting that it could not proceed further with development of the land because the construction bids it had received were excessively high. Total amounts owed on the note at that time approximated $900,000. Toronto Dominion Bank commenced non-judicial foreclosure. Proceedings on April 1, 1975, and purchased the land at foreclosure sale in September 1975 for its bid $650,000. The land was ultimately transferred in December of 1976 to Lexington Properties, Inc., a corporation owned by one Richard Ehrlich, for a purchase price of some $800,000. The Sawyers contend in pleadings and other documentation that at the time of the foreclosure sale, TD had agreed to resell the realty to First City for a price equal to the bank's total investment in it, but that this transfer was delayed until the sale of Ehrlich and his corporation could be arranged, so that neither First City nor its subsidiary again appeared as record title holder. Ehrlich and his corporation obtained development funds for the property from a corporation called Lomitas Properties, Inc., which is a corporation owned and controlled by the majority stockholders, directors, and officers of First City, and which derived its funds from First City. Appellant's view of the facts, therefore, is that the Sawyers were induced to take a non-recourse note for more than half the consideration involved in the sale of their land, the security for which note was made subject to a large development loan. The development borrower then defaulted on the note and arranged with the development lender to foreclose and buy it at foreclosure sale and to resell the development borrower for the amount of the foreclosed sales price plus the balance of the loan guarantee. The practical effect of this transaction, it is alleged, was to wipe out the obligation to the Sawyers and permit First City to proceed with the sale or development of the land without having to pay $650,000 of the purchase price in order to avoid airing the mechanics of the transaction. The agreement between TD and First City was kept secret, and the resale to First City was not recorded, the ultimate purchaser being a puppet of First City set up in an apparently independent corporation borrowing funds from a new and anonymous lending company, but actually deriving development funds indirectly from First City. We are alert to caution that the above construction of the facts from and after the foreclosure sale is that alleged by the plaintiffs who seek the opportunity of proving same in a full-scale evidentiary trial. Interesting. Okay, legal proceedings, Sawyer 1. Sawyer 1 was commenced in July of 1975. The defendants were FC Financial Associates as parent, First City, and later another subsidiary of First City, all sometimes called herein Financial, and TD Toronto Bank of California Bank. The several causes of action all were based upon contractual theories. Reference was made to the land acquisition and development loan agreement executed between Financial and Bank, which provided for the construction of planned residential development in accordance with an existing permit. The Sawyers alleged that they were third-party beneficiaries of that agreement and had been damaged by the failure of Financial to perform in accordance with it. The breach is alleged not only as a simple breach of contract, but as a breach by the defendants of a contractual duty of good faith and fair dealing. The separate cause of action asks for declaratory relief with respect to the contractual commitment. And a final cause of action seeks judicial foreclosure of the Sawyer note. The monetary relief prayed for was the amount of the note, $674,500 plus attorney's fees. The case was tried in February of 1978. By stipulation, the issues were severed for trial and dispositive issues are presented to the judge sitting without jury. The judgment rendered in March of 1978 focused upon the issue of the validity of the waiver by Sawyers of their right to a deficiency judgment. This waiver was found to be effective and judgment was rendered in favor of all defendants on all causes of action. Following affirmance on appeal, the judgment became final in December of 1979. Sawyer 2 was filed in January of 1978, entitled Complaint for Damages Based on Conspiracy and Fraud. It joined as defendants all the parties named in Sawyer 1, and in addition, the ultimate purchaser, Ulrich, and his corporation, Lexington Properties, the new financier of the development, Lomadas Properties, and the number of officers and directors of the financial companies and the bank. 3 of the causes of action of this new lawsuit are based upon an alleged conspiracy among the defendants to cause a default in the bank's note and trust deed, hold a sham sale, and take other action for the purpose of eliminating the obligation to the Sawyers. The only essential difference in the 3 causes of action is the date of commencement of the alleged conspiracy, one alleging the evil motives from the very start of the land acquisition transaction, a second alleging commencement of the conspiracy when Financial defaulted on its note payments, the third alleging commencement of the conspiracy at the time of foreclosure sale. The 4th cause of action uses the same factual allegations as the basis for the claim of intentional interference with contractual relation. Financial's note obligation to the Sawyers. Damages alleged are the same as Sawyer 1, except that additional punitive damages are sought. The procedural history of Sawyer 2 is detailed as follows. Promptly upon filing Sawyer 2, counsel sought to consolidate with Sawyer 1 and move for continuance of the trial of Sawyer 1. This motion was opposed by the defendants, who objected because the issues and causes of action in Sawyer 2 were different from those of Sawyer 1, and also because the case then pending for 2.5 years was scheduled for trial 9 days later. The court denied the motion to continue the trial of Sawyer 1, and it was tried without consolidation with Sawyer 2. In January 1980, the bank and its officers moved for summary judgment on Sawyer 2 upon the ground of Res Judicata effect of Sawyer 1, and also upon the basis of a written release which had been executed in favor of the bank in Sawyer 1, removing the bank from the case before its trial. The Honorable Douglas Woodworth denied the motion based upon Res Judicata, but granted the motion as to the bank only upon the ground of the written waiver. The bank officers moved for reconsideration on the theory that the waiver should be construed to cover them as well as the bank, and this motion was taken under submission by the judge in March of 1980. On July 24th, 1980, Judge Woodworth denied the motions by written minute order. 3. In May of 1980, a separate motion for summary judgment was filed by the financial corporations on the ground that Sawyer 1 was Res Judicata to the issues of Sawyer 2, that the plaintiffs had split their cause of action by attempting to relitigate the same issues in the second lawsuit. The bank officers, whose motion for reconsideration was then pending before Judge Woodworth, joined in this motion, and it was sat for hearing before the Honorable Franklin B. Orfield on July 25, 1980, Judge Orfield ruled in favor of all defendants on the grounds of res judicata and the enforceability of the bank's written release in Sawyer 1. The appellant's appeal from the summary judgment of both Judge Woodworth dismissing the bank and Judge Orfield dismissing all parties. Many bases of appeal are urged. The central and most important issue, however, is the question of res judicata. As reviewed in 3 Whitkin, California, procedure, pleading section 32A, sequential page 1715, a single cause of action cannot be split and made the subject of several suits. If a primary right is so split, determination of the issues in the first suit will be res judicata to the attempt to relitigate them in the second suit, where the res judicata to the attempt to relitigate them in the second suit, where the plaintiff has several causes of action, however, even though they may arise from the same factual setting, and even though they might have been joined in one suit under permissive joinder provisions, the plaintiff is privileged to bring separate actions based upon each separate cause. Res judicata issue. A valid final judgment on the merits in favor of a defendant serves as a complete bar to further litigation on the same cause of action. And that's really the definition right here. The rule. Slater v. Blackwood is the citation in 1975. The question is this, and similar cases, of course, is whether the attempted second litigation involves the same cause of action. Cause of action is conceived as a remedial right in favor of the plaintiff for the violation of one primary right. That several remedies may be available for violation of one primary right. Does not create additional causes of action. However, it is also true that a given set of facts may give rise to the violation of more than one primary right, thus giving a plaintiff the potential of 2 separate lawsuits against a single defendant. I hate this because it makes no sense. It makes sense in one example, but otherwise it's really hard to conceive in different factual settings. The theoretical discussion of what constitutes a primary right. Maybe this will give it clarity. It's complicated by historical precedent in several well-litigated areas, establishing the question of primary rights in a manner perhaps contrary to the result that might be reached by a purely logical approach. Thank you. For instance, the primary right to be free from personal injury has been construed as to embrace all theories of tort which might have given rise to the entry in Panos v. Great Western Packing Co. The plaintiff was injured in a meat packing house. His first action was based upon alleged negligence of the packing house in permitting third parties to come upon the premises and operate equipment. The defense judgment was then held to bar the second suit based upon an entirely different factual theory of negligence, that the defendant himself had negligently operated the equipment. In Slater v. Blackwood, a defense judgment in a suit based upon violation of the guest statute, intoxication or willful misconduct, was held to bar a second suit after the guest statute was held unconstitutional based upon allegations of ordinary negligence. Why? Because the primary right is to be free from personal injury, no matter which 2 theories this guy is asserting. Other examples of torts, is to be free from personal injury but also damage to property. And they do say that here. And that's the only instance that this makes sense. So they're giving it now to try to break this down. Other examples of torts resulting in easily conceptualized types of damages have been settled one way or another by precedent. While one act of tortious conduct might well be deemed to violate only one primary right, the right to be free from a particular unlawful conduct, the resultant 1, injury to the person, and 2, damage to property, have been deemed creative of separate causes of action. On the other hand, one course of wrongful conduct which damages several pieces of property traditionally gives rise to only one cause of action, and that's from Whitkin. Other classes of litigation, however, with perhaps less historical or precedented jurisprudential background are not so well defined in terms of defining how many primary rights derive from a single factual transaction. The tort of Argua v. Johnson of 1979 was unfair treatment of a minority race employee by an employer. Plaintiff's first action was in federal court for back wages under authority of Federal Civil Rights Act. The state Supreme Court determined this was no bar to a second suit in Superior Court for general and punitive damages for defamation and intentional infliction of emotional distress. Although the same set of facts is presented in each claim, one primary right is created by the federal statute prohibiting discriminatory employment practices, and the second primary right is grounded in state common law. Also, the harm suffered was deemed separable, damages for lost wages in the federal action and damages for injury of reputation and peace of mind in the second case, state case. Compare Madsen v. City of Costa Mesa in 1980, where the actionable facts consisted of a lawful arrest of the plaintiff and his abuse and confinement. His first action in federal court under the authority of Civil Rights Act was held to be a bar to the subsequent suit in state court for negligence, assault, and battery. The court found that primary rights giving rise to state common law tort action were the same as those reflected in the Civil Rights Act, and that the Civil Rights action was simply a different way of expressing an invasion of the same primary rights or assertion of a different legal theory for recovery. And that's what I think is going to be applied here, unfortunately, because these guys at the end of the day are just out of money, whether it's because they contracted like idiots or there was a big conspiracy. That's unfortunate. They should have done the conspiracy action first. They shouldn't even have severed it. In the city of Los Angeles, their Superior Court, a federal civil rights action followed by a Superior Court common law tort action, both involving wrongful seizure of personal property, and an appellate court reached the same conclusion and applied the bar of Res Judicata on the ground that the civil rights action was designed to vindicate precisely the same interest in personal property that plaintiff seeks to vindicate in the matter before us. Got it. Oh my God. Long case. One would assume that the question of litigation of claims arising from one transaction, first on the basis of contract and then on alleged tort theories, would have received substantial appellate attention. The authorities, however, are surprisingly sparse. The Restatement of Law Judgments, 1942, Chapter 3, Section 63, page 261, provides several illustrations involving actions to cancel a deed. A failure to sustain the first action on contractual grounds, i.e. failure of execution or delivery of the deed, is held to bar a subsequent action based upon fraudulent procurement, thus suggesting that the primary right is the right to cancel the deed as applied to our case to validate the note, and that this gives rise to only one cause of action, whether it be framed in contract or tort. Respondents rely upon two cases which purport to be illustrative contract actions, followed by separate tort actions arising from the same transaction. That's Olwell v. Hopkins of 1946 and Steiner v. Thomas of 1949. The plaintiff's claim in Olwell resulted from farming operations carried on by a joint venture included a Washington corporation. In the first suit, the action was dismissed without a trial of the substantive issues on the ground that the corporation had never qualified to do business in California, with the result that the contract upon which the suit was based is void. The second suit, based on the same transaction, alleged fraudulent concealment of facts and prayed that the defendant be declared constructive trustees as certain realty. While this scenario would seem to pose a problem similar to that of the case before us, it was resolved without addressing the issue of the existence of separate causes of action in contract and for fraud. The court assumed and presumably counsel did not argue to the contrary that there was only one cause of action, and that the second suit was merely the alternate statement that of that one cause of action, see Olwell v. Hopkins supra. The question directly addressed by the court was the effect of dismissal of the first suit without a trial on the merits, and whether dismissal on procedural grounds would operate as a bar to the second action, recognizing that in order to constitute a bar, the dismissal must have been the following: an adjudication on the merits of controversy. They're saying it didn't do that. So the second case was held. So how did the first case not reach an adjudication on the merits. Alright, whatever. In Steiner, 2 successive actions were brought against an administrator of a decedent's estate for the purpose of recovering a certain parcel of real property, which had been transferred to the decedent by a plaintiff before the decedent's death. The first action was for rescission based upon fraud, alleging the realty had been distransferred so as to permit the decedent to collect rents, and that the decedent had promised to reconvey the property at a later date. The second lawsuit was based upon an alleged breach of an agreement to devise the property of the plaintiff, as evidenced by 2 letters from the decedent to the plaintiff. The court resolved the question of Res Judicata against the plaintiff, focusing on the identity or similarity of the facts litigated in the first suit as compared to those in issue at the second suit. The court stated the fact that in the former action the merits of all facts were determined and relief was denied. Upon presentation of that special plea in the instant action, the court had merely to decide whether the facts alleged in the first suit for rescission of contract were substantially those alleged in the second action for breach of the same contract. Steiner v. Thomas. This court thus construed the situation as one which alternative remedies in contract were successively brought related to the same contract, rather than a case in which the action on contracts was followed by an action for intentional tort related to and part of the transaction giving rise to the contract. Neither Orwell nor Steiner appears controlling. The case before us is not one in which the same factual structure is characterized in one complaint as a breach of contract and the other as a tort. The first action is solely on contract and is based upon the note, deed of trust, and loan and development agreement. At the time of trial, the principal issue litigated was the effectiveness of the waiver of deficiency judgment, and this issue was presented in the context of contractual theories. There was no contention and no evidence was presented relating to a possible invalidation of the waiver on grounds of fraud, misrepresentation, or any other tort. Sawyer 2, of course, had its object collection of the same promissory note, which was the subject matter of Sawyer 1, but the basis of the claim is completely different and rests upon a completely separate set of facts. The complaint assumes that and admits that the forms of the waiver of deficiency and the subordination were technically appropriate and enforceable. The pleading reaches beyond these documents, however, to highlight other conduct of parties alleged to be tortious. The core of the alleged wrongful conduct is an agreement among the parties to conduct that is characterized as a sham foreclosure sale, and only substantial effect of which would be secretly to discharge the obligation of Sawyer, leaving all other parties in essentially the same position as prior to the sale. Surely, one's breach of contract by failing to pay a note violates a primary right, which is separate from the primary right not to have the note stolen. That the 2 causes of action might have been joined in one lawsuit under our permissive joinder provision does not prevent the plaintiff from bringing them in separate suits if he elects to do so. While the monetary loss may be measurable in the same promissory note amount, and hence in a general sense the same harm has been done in both cases, theoretically the plaintiffs have been harmed differently by tortious conduct destroying the value of the note than by the contractual breach of simply failing to pay it. We conclude, therefore, that Sawyer 2 is based upon separate and severable cause of action from that litigated in Sawyer 1, and that it was error to grant summary judgment on the ground of Res Judicata. Nice. Okay. Of course. Different facts. Estoppel. A second prong to appellant's argument about the summary judgment ruling as respects Res Judicata is that the moving parties were stopped to deny the separate issue of the 2 causes of action because they had earlier opposed the motion to consolidate the 2 cases. Appellants rely upon United Bank and Trust v. Hunt, where the court at page 345 stated, where counsel by timely notice called to the court's attention the pendency of other proceedings covering kindred matters and strive to have the same embrace within the scope of the inquiry, and such attempt is successfully blocked by opposing counsel, and the trial proceeds to investigation on the specific issue before the court. Counsel who successfully in preventing the consolidation of issues cannot be heard later to object to a trial of the related matters upon the grounds of Res Judicata. The course pursued by court and counsel was tantamount to the express determination on the part of the court with the consent of opposing counsel to reserve the issues resolve for future adjudications. Citations omitted. Litigants cannot successfully assume such inconsistent positions. The inconsistent position asserted to have been taken by defense counsel was at the time of the hearing a motion to continue the trial of Sawyer 1. At the hearing the motion for continuance of February 6, counsel for the defendants did argue that the case could not be continued to permit consideration of a consolidation motion because consolidation would be improper by virtue of different theories and cause of action Sawyer 2. However, no express argument was made about nor consideration given to the question of the res judicata effect of the prior trial of Sawyer 1 in light of the long period of preparation for trial and then once continued trial date and pending only 9 days hence. The trial court presumably considered further continuance to be prejudicial to the rights of the defendants. A court is not required to grant the continuance of a trial when pleadings have been completed, adequate time for discovery have been provided, and the issues are joined and one side is ready for trial, even though the moving party alleges newly discovered facts or newly found issues which suggest more discovery or an amendment to the pleading. The reasonable interpretation to be derived from a review of the record in Sawyer 1 was that the court denied the motion for continuance because Sawyer 1 was ready for trial, had been delayed previously, and should not be delayed further. Therefore, while we have determined that the motion for summary judgment should not have been granted on the ground of res judicata, we must agree with the trial court that the moving parties were not stopped by their prior conduct from making the motion. Danforth, acting presiding judge, concurs, and so did Justice Weiner. Concurring, I conclude defendants except for the TD Bank and its officers were stopped from raising the defense of res judicata. Accordingly, I agree with the result reached by the majority. Plaintiffs filed their first case in July 1975, their second in January of 1978. On January 13th of 1978, plaintiffs moved to consolidate both cases because some of the parties and certain of the issues were the same. Unable to serve all defendants, plaintiffs' motion to consolidate was reset beyond February 15th of 1978 and the trial date in that case number. Pending hearing on that motion, plaintiffs moved to continue the trial to allow the court to consider the motion for consolidation. Counsel for First City defendants in Sawyer 1, one of whom is appellate counsel here, opposed the motion for continuance by saying there was no basis for consolidation, arguing further that plaintiffs are pursuing theories of action for conspiracy and thought in the second case number, whereas in the above captioned action, plaintiffs are pursuing theories of breach of contract, declaratory relief, and judicial foreclosure. The issues raised in the two cases were necessarily and substantially different. And defendants' counsel made the tactical decision to oppose the continuance of the assumption that if successful, they would then be able to prevent litigation in the second case on the basis of res judicata. It would have been simple enough for them to call the court that res judicata was involved. If they had done so, the judge considering the motion would then have been able to evaluate all relevant factors affecting his decision before exercising discretion in making his ruling in light of the language which defendants selected to oppose the motion for the continuance, the ruling on which prevented the court from ever considering the merits of plaintiff's request for consolidation. It was reasonable for both the court and plaintiff's counsel to conclude defendants' opposition to the continuance would not prevent a trial of the second case in which the issues were represented to be necessarily and substantially different. Accordingly, reasonably interpreted, defendants' actions fall within the narrow rule of United Bank and Trust Co. v. Hunt. Once having represented to the court there were two different actions with different issues, they may not now stop plaintiffs from having a full trial on those different issues. Notes and questions regarding claim preclusion. There's primary rights theory, there's the cause of action, there's the primary rights determined by precedent, there's declaratory judgment exception, there's final judgment on the merits, and affirmative defense before we get to collateral estoppel. So let's get through this. Note 1, Primary rights theory. The primary rights theory was developed by Professor John Norton Pomeroy in the 19th century and adopted by the California Supreme Court as early as 1887. See Hutchinson v. Ainsworth, 1887. Under the primary rights theory advanced by Pomeroy, a cause of action consists of a primary right possessed by the plaintiff, a corresponding primary duty, and the defendant, and a wrongful act by the defendant constituting a breach of duty. Crowley v. Cattleman, 1984. J. Pomeroy Remedies and Remedial Rights, section 453 at 487 from 1876 for historical analysis of the primary rights theory and Res Judicata. See Walter W. Heiser, California's Unpredictable Res Judicata Claim Preclusion Doctrine from San Diego Law Review of 1998. 2. Cause of action. The central feature of California's claim preclusion doctrine, as Sawyer illustrates, is that a single cause of action cannot be split and made the subject of separate lawsuits where a plaintiff has more than one cause of action against a defendant. However, the plaintiff may join them in one lawsuit but is not required to do so, either by rules of joinder or of res judicata. In other words, a plaintiff who has two causes of action against a defendant may, with two separate lawsuits, a judgment in one lawsuit will have no claim preclusive effect on the other. A. Primary right. This makes the definition of cause of action of central importance. As Sawyer illustrates, the California courts define a cause of action for purposes of claim preclusion according to the primary rights theory. The violation of each separate primary right gives rise to a separate cause of action and potentially a separate lawsuit against the same defendant. B. Harm suffered approach. How is primary right defined? More importantly, how do the courts determine whether a set of facts gives rise to only one primary right as opposed to multiple primary rights? The most frequently quoted response to these questions is from Agarwal v. Johnson, 1979, under the primary rights theory adhered to in California. It is true there is only a single cause of action for the invasion of one primary right, but the significant factor is the harm suffered. That the same facts are involved in both suits is not conclusive. How significant was the harm suffered factor in Sawyer v. First City Financial Corp? 3. Primary rights determined by defendant. Despite the general uncertainty in defining primary rights, some applications of the theory are relatively settled by precedent. Litigants can feel reasonably comfortable in determining whether one or two lawsuits are permissible in such circumstances. Perhaps the most frequently encountered application involves a tort victim who simultaneously suffers, typical example, both personal injury and primary damages caused by the defendant's single act. A typical example is negligence litigation arising out of a crash of two cars where one driver sues the other. The resulting personal injury to the plaintiff's driver is the separate primary right from the property damage to the plaintiff's car and may be issued in two separate lawsuits. C. Holmes v. David H. Bricker, Inc. of 1969. However, a breach of contract that results in injury to person and property violates only one primary right and therefore gives rise to only one cause of action. Other areas relatively settled by precedent are also suggested in Sawyer. One wrongful act which results in injury to several pieces of property traditionally gives rise to only one cause of action, as does one wrongful act which results in multiple personal injuries to a plaintiff. See Sawyer in cases cited therein. Swartz in Druber v. City of San Diego. Consequential damages did not support a second cause of action. That's in 1992. Note 4. Declaratory judgment exception. Under the Declaratory Judgment Act, a party may ask the court for a binding declaration of rights and duties. CCP 1060. This act also provides an exception from the bar of res judicata claim preclusion for declaratory judgment, stating no judgment under the chapter shall preclude any party from obtaining additional relief based on the same facts. CCP 1062 in Mycogen Co. v. Monsanto Co. 2002, the Supreme Court construed the Act's exception to claim preclusion as applicable only where the plaintiff's initial action seeks pure declaratory relief and not where the action seeks both declaratory relief and additional coercive relief such as damages, specific performance, or an injunction. Because plaintiff Microgen sought and received both declaratory and coercive relief in form of specific performance in his prior breach of contract action, Res Judicata precluded Microgen from seeking additional relief in the form of damages for the same breach of contract and subsequent action. 5. Final judgment on the merits. The doctrine of Res Judicata applies only to final judgments orders. American Enterprise, Inc. v. Van Winkle of 1952, Restatement Second of Judgment, Section 13, 1982, which constitutes a final judgment under what constitutes a final judgment under California doctrine. The California rule is that a judgment is not final for purposes of Res Judicata if it is still open to direct attack by appeal or otherwise. Archewall v. Johnson. Consequently, an order for judgment is not final under the California rule for Res Judicata purposes during the pendency of an appeal, and even though no appeal has yet been taken until the time for appeal has expired. See Archewall v. Johnson 10 and CCP 1049. A and B. A. In order to have Res Judicata effect, a judgment must not be final, but must also be rendered on the merits. Wilson v. Biddick of 1965, Section 19, Restatement Second of Judgments of 1982, the paradigm judgment on the merits is one entered after a full trial of issues of fact and law, rendered by a judge or jury. Restatement Supra 19, Common A. This includes a judgment rendered on a directed verdict and a judgment notwithstanding the verdict. B. When a judgment is rendered without a full trial on the facts, the question of whether it is on the merits becomes a little more complicated. When not dealing with a paradigm, a particular judgment must be closely scrutinized to determine whether it is or is not an adjudication on the merits. For example, although a default judgment is on the merits, English v. English, 1937, a summary judgment is only if based on a determination of the merits as opposed to some other grounds, such as statute of limitations, Koch v. Rodlin Enterprises, Inc., 1990. And last, note 6, affirmative defense. Res Judicata must be properly pled or proved at trial or it is waived. See Wolfson v. Hathaway, 1948, Parker v. Walker, 1982. See also CCP 456, 1908.5. The normal and appropriate method of raising Res Judicata is by an affirmative defense. See Parker v. Walker, Supra. The last section of the book is most likely is going to deal with California's issue preclusion, and that is going to be another 5 pages in a separate report.